Yeah, I'd love to get the recording since I won't be able to stay for the whole thing. So that would be great.
Great. Awesome. Well, as you can see, Jeff is with us. We started introducing a few of us earlier. Do we want to keep going? Susan, you want to go?
Sure. Hi, I'm Susan Adams, the Executive Director of the International Association of Healthcare Central Service Material Management.
Awesome. Debbie?
Good morning, I'm Debbie Trueblood. I'm a senior consultant with AMC.
Thanks. Chris?
Good morning, Chris Glatz, President, Glatz Management Services. We're a full service association management company out in the Chicago area, and glad to see everybody.
Thanks. Denise?
Hey, Denise Fryer, I am CEO of the Strategic Account Management Association, headquartered in Chicago also.
Thanks. Marilyn?
Good morning, I'm Marilyn Jansen. I am the Executive Director of Business Development, working close with Debbie Trueblood at Association Management Center. When we're in the office, we're located right near O'Hare in Chicago.
Nice. Barbara?
Hi, I'm Barbara Rango. I'm an executive director with Weiser, which is a part of Naylor Association Management. And I'm in the suburbs of Chicago as well.
Thank you. Heather?
Good morning, I'm Heather Case. I'm the CEO of the International Council for Veterinary Assessment, and I'll keep the trend going. We're in the northwest suburbs of Chicago as well.
Fantastic. Linda? Welcome.
Hi, can you hear me okay?
Yeah, we can hear you great. You want to tell Jeff really quickly where you're from?
Oh, sure. I'm Linda Carradine Poinsett. I'm with the American College of Prosthodontists, and we're located in downtown Chicago.
Thanks. So we've got it's all Chicago today, Jeff. Sorry, we don't have any surprise visitors from the other areas.
It's all good.
Do you want to tell us really quickly a little bit about you, the great and fun things we should know? Thanks again for doing this.
Sure, absolutely. And Marilyn and Debbie, it's nice to see you guys. As you know, I serve as outside counsel to Association Management Center and do a lot of work with your company. So I'm Jeff Tenenbaum, managing partner of Tenenbaum Law Group, based in Washington, D.C. We are a 3-lawyer boutique focused exclusively on the representation of associations and other nonprofit organizations, primarily as outside general counsel. I've been practicing law and private practice in DC for 26 years. Got my start at ASAE when I was going to law school at night, following a few years on Capitol Hill, and spent most of my career chairing the nonprofit practice at a large law firm called Venable. Beginning of last year, opened up Tenenbaum Law Group. We represent about 450 associations and other nonprofit organizations and related entities like a lot of association management companies as well, in connection with a very, very broad array of legal issues facing associations. We opened the firm January 1st, pandemic hits in early March. And so not surprisingly, as kind of the legal practice often tracks what's going on with your clients and what are the challenges that you're facing. And certainly one of the biggest challenges over the last 18 months or whatever it's been, has been meetings and conferences and contracts and cancellations and potential cancellation penalties. And now with the gradual potential return to in-person conferences and meetings and return to the workplace, all of the related issues about how to protect the association or the AMC from liability risks. Should we have vaccine mandates, mask mandates? What sort of exceptions do we need to make? Should we require our attendees to agree to liability waivers? All of these issues keep us extremely busy every day. Last year we spent most of the year working with hundreds and hundreds of associations in getting them out of their meeting and conference contracts while avoiding cancellation penalties. And we had a really, really high success rate, probably about 98%, I think, in getting our clients out of their contracts with paying little or no cancellation penalties, primarily by using what's called the force majeure clause in meeting contracts in order to do that. And part of the reason we had so much success doing that is that so many states and cities and counties had bans on large gatherings in place throughout last year. Well, as vaccines came online this year, those bans have largely disappeared. There was, the early part of the year, or I'd say, come spring, coming into early part of summer, everyone's moving full speed ahead with planning in-person meetings. A number of them have happened. I've been to some, a number of our clients continue to have, and some really successful in-person meetings. And we do a lot of work counseling our association clients on how to mitigate the risks on some of the issues that I already talked about. But unfortunately now, with the kind of the curve of the pandemic, we are spending time every day counseling associations who want to cancel or postpone, particularly their fall 2021 meetings and kind of going into the winter, because they're just not comfortable having them, or they don't, they're surveyed their members and they don't think they're going to get enough attendance. So they're deciding to pivot again to a virtual meeting. Working with associations to help get them out of or postpone those meetings and conferences has been much more challenging than last year, because we don't really have, in most cases, depending on the language of the force majeure clause, we don't have the threat of a force majeure penalty-free termination because, outside of Hawaii and maybe a few other small, cities and counties, there are no more bans on large gatherings. So it makes it very difficult to point to a force majeure clause that says, you can only get out of the contract if it's illegal or impossible for you to hold the event. It's hard to make that argument to a hotel lawyer saying it's illegal or impossible when there's no ban on holding the event. I say generally because if your clause if your force majeure clause says illegal, impossible, or commercially impracticable, that kind of opens the door potentially to force majeure termination. But unfortunately, most force majeure clauses don't have that additional phrase. They just refer to illegal or impossible. So it's made it much more challenging. We're having to come up with all sorts of additional leverage to try to compel or convince a hotel or convention center to postpone an event, but it's definitely a lot more challenging than last year. So that's kind of the overview of kind of the meeting contract and conference situation as it stands right now. But I really want to reserve most of the time here today for your questions, and you tell me what issues you want me to talk about, dive in deeper on any of these topics.
Is anybody struggling with that issue that he just mentioned, the meetings right now?
I would just, this is Chris, I would just chime in, Jeff, that I have been pretty successful renegotiating the food and beverage minimum. Because to your point, we're not getting the ability to cancel anymore because there is no restriction on group sizes, at least here in the Chicago area. So I've been trying to play that, I'm gonna use the word game, to reduce food and beverage minutes because the numbers are just not there for us. I mean, an event that would normally have 500 people, I've got about 225. An event that was, 150 people, I had one last Thursday, dinner, downtown hotel, big F&B. I only had 75 people, of which, by the way, 62 showed up.
And those are the percentages that we're seeing generally when in-person events are occurring. And that's one of the things I wanted to talk about. So if when a client comes to me and we usually get on a Zoom call and we take a look at the contract in advance and then we talk it through. Some associations say, look, we can't have the event. Our board doesn't want to do it. We just don't feel it's safe. Too many of our members are under employer imposed travel bans. In certain sectors, that's still a very big thing. In some sectors, it's not. So some say we just want to get out altogether and help us, give us the options, the tools, the leverage to figure out how to do that. But others, looking at, really no chance of a successful force majeure penalty-free termination, are saying, look, we're going to go ahead with a meeting. We're going to maybe do, if it's a bigger conference, we're going to do a hybrid, part in-person, part virtual, or even no hybrid, but just saying we're going to go ahead and have just a smaller event, but we really want to go ahead and have the event and help us pull it off in a way that protects the health and safety of our members and our employees and whatnot. One of the critical things, and you just flagged it, Chris, is that you have to be sure that you work with the property hotel, convention center, restaurant, whatever it is, to reduce your guaranteed minimums for food and beverage, as you said, but also for sleeping rooms, if it's an event with sleeping rooms, because most of these contracts have what's called an attrition clause that says if you fail to meet at least 70 or 80% of your guaranteed minimums for food and beverage and or for sleeping rooms, then you get hit with significant attrition penalties designed to kind of make the venue whole for what they would have earned. And those can be extremely significant. And on the sleeping room side, it's made even worse because sleeping room revenue is largely paid by your attendees if you have an event. Right? It's not paid by your association. Maybe you're paying for some staff rooms and maybe board members, but other than that, it's paid by your attendees. Yet in an attrition clause, it's paid by you. So that makes it doubly worse or triply worse, however you want to look at it. And so what you have to do is you got to, as soon as you possibly can, as soon as you know you're going to go ahead with the event, but you know you're going to have significantly reduced attendance, you have to work with the venue to reduce your minimums for food and beverage and sleeping room and the corresponding attrition penalties. We've had a lot of success in some cases of getting the venues to eliminate attrition penalties altogether because they're so desperate to get people in the door. And we've heard that anecdotally from a lot of our other clients as well. But it's an absolutely critical point, and otherwise, yeah, you're going to really be nailed by it. And the sooner you can do it, the better. That's another thing. If you go in at the last minute and you ask for it, you're not likely going to have nearly as much success.
Yeah, we're facing we're facing all of the above. We had a conference scheduled for October, and we did negotiate. We reduced our room blocks, and they were very willing to work with us on that. However, just this week we made a decision to cancel altogether, and we're working through exactly what you said, working with the hotels, working with our attorney to send the cancellation letters. But we did have initial conversation with them about rebooking for another year, and they actually seemed open to that, but we're still in negotiations.
Okay, so let's talk about that for a second, because unfortunately, we've had way too many associations recently come to us and have gone down that path like you have, decided, relatively last minute to cancel just because this damn pandemic is not going away. Which is an understandable decision, but how you go about doing this is critical. And we've seen so many associations make some really big mistakes that is going to end up costing them. One thing that we've seen, I don't know why this is happening, but it's a definite trend, is that a lot of your associations work with independent third-party meeting planners to kind of be the interface with the hotels. And we have seen too many of these meeting planners. I'm not generalizing, but we've just seen anecdotally quite a number of cases where the meeting planner went to the contact of the hotel and said, Association X is going to cancel the meeting. Now let's figure out what do we do next. It's the worst thing you can do. And what happens almost in every one of these cases, the hotel turns around and they say, okay, here's a bill for your cancellation penalties, hundreds of thousands of dollars or more. And then you start the negotiations, but you're in a hole. If you're going to cancel, and we have a ton of experience. We've worked on probably at this point close to 1,000 different meetings and conferences over the last 18 months and helping to figure this stuff out. One of two ways to go about the negotiation. One is you do not say we're going to cancel, but you talk about your challenges. Some of your attendees are not going to come. They're under travel bans, whatever else. And we want to have a successful conference. You want to have a successful conference, you, the venue, but we just can't pull it off. So, let's talk it through. Let's work out some solution that works for both sides. But don't say you're going to cancel to start that negotiation. And depending on the relationship you have with the property and many other factors, you might well have success, and I'll give you some ideas for those negotiations in a second. But the other way to do it, especially if you have an arguable force majeure case, particularly if your force majeure clause has those words commercially impracticable, or some other language that opens the door to making a credible argument that you have a case for force majeure, even though the state of Illinois and city of Chicago or your county doesn't have any bans on large gatherings. have your attorney draft for you a really, really strong force majeure termination notice that lays out all the different reasons why you have a strong case for force majeure. Send it off, and we generally recommend it come from the association to the hotel with a copy to your attorney. That is the beginning of the negotiation, because they're not just going to accept it and say, oh, okay, sorry, go away. I hope to see you back here next year. But you're using it as leverage to open the door to a more successful negotiation. And we have had tremendously great success even this year in going that route, particularly where the force majeure language was more favorable. Now, if you're going, now, regardless of which route you take, when you negotiate, we have seen some cases where the association was looking to push, say the fall 21 conference to next year, and they've been able to negotiate with the hotel or the convention center to be able to do that without any cancellation penalties. But that's not the majority. That is definitely the minority. Generally, we're finding that you have to give something more than just pushing it back to next year. Yes, they are, eager to have you back, especially when you're going to have more people there. But usually what we're finding is you have to sweeten the pot with something more than that. It's not enough. So how else can you sweeten the pot for them? Obviously one thing is if you have a credible threat of a force majeure termination, that's leverage, right? That's kind of negative leverage, and that it's a threat, and that certainly can help. The rest of your leverage is generally going to be positive leverage. Like, how can you sweeten the pot for them? Are you gonna? We had one yesterday where they said, I think the hotel came back and said, we'll do it if you push your 2021 meeting to 2022 and rebook for us in your next open year, which I think was 25 or 26. So, asking for 2 conferences. That is generally enough to, in most cases, to sweeten the pot. But a lot of times, your association or your management, your board, you don't want to do that. Maybe you don't want to go back to that same property. Maybe your members like to have more variety, and where you're not a fan of the property, whatever else. And so if that's the case, then you're going to have to sweeten the pot in other ways. One of the most successful tools that we've utilized is advanced deposits. So hotels want cash, and they need and want cash now. Of course, they would love cash in the form of cancellation penalties. We don't like that because cancellation penalties are like throwing your money away. But we don't generally, in negotiating new, hotel or convention center contracts, we try to minimize advanced deposits to the greatest extent possible. But when you're in a situation where you're facing significant potential cancellation penalties and you have to find a way to sweeten the pot, giving the hotel a bigger advanced deposit in lieu of cancellation penalties for whenever that rebooked conference is, essentially whatever your spend will be, which will be food and beverage and some other expenses as well. Again, not the sleeping room part, because that's paid by your attendees for the most part. But whatever your spend is going to be, you're going to spend that anyway. And so, if you have the money, paying it in advance, and I'm not saying all in advance, maybe you spread it out. We've had some success in spreading it out over, 4 separate equally spaced payments or something like that. But, even as high as your food and beverage minimums, you're not throwing money away, you're just prepaying it. And that's been a very effective tool. Another tool that we've used that's helped to kind of bridge the gap and sweeten the pot a bit has been, if you're going to push your conference back and increase your food and beverage minimums, hold a nicer event for your attendees, hold an extra reception or dinner or whatever else, better, food, wine, cocktails, all the rest. If you can afford it, that can help to sweeten the pot as well. And then one other thing, sometimes maybe you're not interested in committing to your annual conference again with that property, but maybe you could throw in a smaller meeting, like a board meeting or a regional conference or a committee meeting or something like that, a year or 2 from now. And generally, the sooner those future meetings can be booked, the more incentivized the hotels are. The further you push it out, the less interesting it is to them, but they're still interested in getting things on the books. So those are some of the techniques and also the pitfalls, in terms of just don't say we're canceling, now let's talk about what's next. Do not say that. It's really important. And make sure you don't say it to your members either, by the way. Your registrants, your attendees, because hotels have a way of finding out about this. This came home to roost for some associations last year, where they told their members they were, canceling the in-person and going virtual. The hotel found out about it, and they sent them a bill for, hundreds of thousands of dollars in cancellation penalties. So be really careful how you communicate. I frankly thought we were done with all of this, earlier this year. I thought, I gave so many webinars last year on this topic, probably like 75 last year.
Wow.
So much talk about force majeure and everything else. And I really thought we were done with it. And we're going to spend all our time talking about how to safely hold in-person meetings and conferences. But we're not, at least for some. So I'll stop there, and then let me know, if you want me to talk about kind of holding in-person events and some of the things that you need and want to do in that regard.
Jeff, I have a question, and that is, as we look at new contracts, not ones that are continually renegotiating, but new contracts, is there some buzzwords, or you mentioned earlier, you mentioned impossible versus impractical, which caught my ear. Are there, when we're looking at those contractual paragraphs, kind of force majeure and such, is there something that has come out of all of this that we should definitely make sure we have in our contracts?
Yeah, I mean, there's a lot, and the regular schedule contracting process continues. We review these all the time. I think associations have always paid attention to their meeting contracts, but there is a renewed focus, much more than I've ever seen before. More of our clients are bringing those contracts to us when they did not in the past, because they realize that, the devil's in the details, and, a few little words here in a force majeure clause, for instance, can make a huge difference in your negotiating power and leverage with a hotel or convention center. So yeah, I would absolutely, the force majeure clause is critical. Of course, the hotels recognize this as well, because so many of them got burned last year, with associations canceling without penalty, because the associations had more favorable force majeure language. So there's a definite tension that we're seeing in these negotiations. You really need to focus on, and there is no one standard clause. Everyone's a little bit different. We are seeing a number of hotels come back with adding COVID-related language into the force majeure clause. But when you drill down, it's actually not very favorable. And it's only kind of a very narrow circumstance where it would apply. Frankly, in our opinion, when I say our, my two colleagues and myself, because we do this so often, if you can get the words commercially impracticable, you don't need any specific reference to COVID or anything like that. But if you can get a specific reference to, if an event like a pandemic makes it commercially impracticable for you to hold a meeting, then you have the right to get out without penalty. That is it has a legal meaning to it. And it's much broader than just being illegal or impossible. And commercially impractical could mean, well, majority of your attendees have said, or registrants have said, they're not going to come. Or a number of, a large percentage of your exhibitors or your sponsors or whatever the case might be have said, we're not going to come, and we're pulling out if you hold an in-person meeting. That arguably makes it commercially impracticable for you to hold the meeting. So you're going to expect some pushback, but that's what I'd like to see. We're seeing a lot of clauses now that are saying, like, the hotels are proposing clauses that say, if COVID, causes you to not be able to have the meeting, so long as you rebook similar size meeting within 12 months, and you pay a certain amount in cancellation penalties, but a lesser amount, we'll let you do that. So that's kind of an interesting approach. Again, not always super favorable to the association, and sometimes pushing back 12 months doesn't work because you've already contracted for your annual meeting for next year in another place. So you really want to focus on that provision and talk with your lawyers and be creative in how you tackle that. Another thing that we've learned from all of this, and that's really important to focus on, is you're seeing it for in-person meetings this year, but I think we're going to see it for next year and perhaps permanently, which is no one really knows what the future of in-person meetings and conferences are going to be like. Whether it's for, budgetary reasons and a lot of members or their employers deciding, they got away with not spending money on conference, registration and expenses and everything else. for the last year and a half, maybe it's worthwhile to continue it, a demand for more virtual options. Whatever the case may be, there's a strong likelihood that in-person conference attendance is going to be reduced for the foreseeable future. Yet you have contracts, existing ones and potentially new ones, that have guaranteed minimums based on pre-pandemic expectations. And so just like I talked about earlier, that if you're going to go ahead with in-person conference, you have to work with the venue to reduce your guaranteed minimums for food and beverage and sleeping room. Similarly, for new contracts and new future conferences, you don't know what it's going to look like. So you can't just go by your numbers from the past and putting those numbers in. You want to try to get guaranteed minimums that are lower than what you had in the past. But even more importantly, at the same time, you need to make sure you have enough room, like big enough room block. And that's usually the biggest thing. You don't want to come up short. So it's a balance, but ideally what you want to be able to do is have greater flexibility than you had in the past in reducing those guaranteed minimums at certain points in time leading up to the conference. Now, they're not going to let you do it at the last minute, but we're pushing for more flexibility, and we've had a lot of success in getting, say, the hotel to agree, that at X number of months out or years out or whatever it is, at certain points, you have an ability to reduce those minimums by a certain percentage. They're not going to let you just do it however you want, but up to 10% or 20% or whatever. But give yourself the flexibility as you start to see over time what your in-person conference attendance is likely to look like. You want to have the ability to reduce those minimums and the corresponding attrition penalties to the greatest extent possible. Another thing that we're trying to do in negotiating new contracts is, and it sounds kind of opposite from what I said earlier about using the payment of advanced deposits as a way to try to negotiate your way out of cancellation penalties. That is absolutely a tried and true tactic. At the same time, with new contracts, what we found last year is that those associations that did not have deposits with the venues, or it had relatively small deposits, had a much easier time convincing the property to let them out of the contract under a force majeure, threat of a force majeure termination, and just rebook the meeting without any penalties and without having to offer up any other leverage. But those that had significant deposit money, generally speaking, found a much more difficult time, because the hotel, basically that money's gone. If the hotel says, we don't believe you have an argument for force majeure, we're going to assess you cancellation penalties, and we're going to apply that deposit toward your cancellation penalties. That really affects the negotiating power of each side. And so generally speaking, we don't want you to pay big deposits, yet hotels have learned from their mistakes over the last 18 months, and they are now pushing for much more deposit money than we've ever seen before. And they're asking for it all up front. And so you want to try to negotiate down that those deposit amounts to the lowest extent possible. And B, you want to spread it out. And we have had great success doing that. So instead of paying it all up front when you sign the contract, you spread it out over 4 payments or whatever it is at certain intervals leading up to your conference. Another thing that we learned from the pandemic is that because of the economic effects of the pandemic, there were a lot of hotel closures, both temporarily and permanently. We saw some bankruptcies, like here in DC, a big conference hotel, the Marriott Wardman Park, went into bankruptcy. We've seen some change in management of hotels, so it's owned by, it's a private folks, but it's managed by Marriott or Hilton or whatever the case is. And we've seen kind of a change in the flag. You want to make sure that you have provisions in your contract that allow you to get out of the contract if any of those things happen. It's not something that a lot of folks focused on before, but it's really important. It's really important to do that. And then one other thing that we're seeing is that in some places, some hotels are open, but they're not fully reopened. They still have restaurants and other facilities, maybe a spa or other things that are not fully reopened due to COVID. And you want to make sure, even without a provision in your contract, you have an argument that if that hotel is not, at least material parts of it are not fully reopened, that's not what you contracted for. Like if you're like a lot of associations, your members, they go to your events and then they hang around at the hotel bar at night. And if the hotel bar is not open, That's, you know, a key part of a lot of association meetings and conferences. And so that gives you an argument, if you're looking to get out of the contract, that the hotel is an anticipatory breach of contract because they're not fully reopened in the way that you contracted for. But we try to go even further in new contracts and putting something in there that says, if you know your facility is not largely fully reopened, that gives the association an ability to get out penalty free. So those are a few suggestions. I could go on, but I'll stop there.
That's great. Thank you. Linda, you had something in the chat you wanted to ask?
I did. I had a question more specifically around the requirements of what the organization can impose on the attendees around vaccinations. I really don't know how you could police it or insist on it happening, but what can your organization put in place? Because, you know, my biggest fear is that, you know, someone may very well have been vaccinated, but still end up transmitting COVID. And then, of course, we could open ourselves up to some liability from that standpoint. So I don't know what kind of disclaimers we can put in place, but I'm curious what your thoughts are.
Okay, I figured we'd be talking about this. So there's a whole bucket of issues here. Let me kind of start at a high level. So first off, you've touched on a number of things. One issue is liability risk for the association. You know, trying to avoid liability. Someone contracts COVID at your event, or a bunch of people do, and they say that, you know, they file a suit claiming that the association was negligent in how it held the conference. Therefore, it should be held liable for any, you know, damages, expenses, pain and suffering, you know, whatever else that someone endures as a result. So how do you mitigate your liability there? Well, there's a number of things you can do. First off, you talked about disclaimers, but really the term is a liability waiver. And that's basically something that your attendees would sign or click and accept that they agree, that says COVID is a, you know, very risky, highly transmissible virus. We recognize that there's no way to completely eliminate all the risk. If I contract the virus at your event, I agree not to hold you, the association, liable. And by the way, I agree to follow all the rules and protocols that you put in place. Having all of your attendees and requiring them to click and accept, if it's an online registration or whatnot, they click and accept that they agree to that liability waiver, to me is a no-brainer, absolute no-brainer. Liability waivers are not always fully bulletproof, and they can be kind of shot down by the courts in some instances. But in many instances, they're not. And if you're not grossly negligent, and most associations are never going to be grossly negligent in how they conduct their conference, that liability waiver has a very good chance of being upheld. So to me, it's a no-brainer to use a liability waiver, but that's not enough. That's definitely not enough. And it's not enough, frankly, to make your attendees feel safe. And that's a part of this. We're seeing a lot of this is coming not from the top down, from the association's management or the board, but from the bottom up, from the attendees saying, we want to attend, but we want to feel safe. And there's a lot of push in some associations for vaccination mandates coming from the ground up. Never mind from the top down, because that also can help make a safer environment for your attendees. But before I get to vaccination mandates, in terms of the overall, you know, how do you avoid being negligent? You first start, so avoiding negligence means that you are meeting the prevailing standard of care for how to conduct large meetings and events. And that standard of care, you can't just find it in one place. It comes from lots of different places. Basically, what is kind of the, you know, the normal prudent best practices for how to conduct large meetings and conferences in a safe way? You first look to, are there any binding laws, regulations, executive orders that apply? And that stuff largely does not come from the federal government, but it comes from state and local governments. And there still are, while there's not nearly the kind of orders and rules that were in place last year in terms of mandating social distancing and other things like that, there are a number that are still in place at the state and city and county level. Like in DC, where I am, we have an indoor mask mandate. So if you're holding a meeting in DC, you obviously have to comply with the indoor mask mandate. And police it as well, you know, again, if you want to avoid being negligent. But then another place that you absolutely want to look is to the CDC has guidance on their website for large meetings. And I have a few articles that we've written, one about like a model liability waiver, and I have another article about how to hold, how to mitigate your liability risk from in-person meetings. And that has a link to the CDC guidance. I'll send those article links to Jill and she can forward them to all of you. But take a look at that guidance. It's not mandatory, it's not binding, but it definitely helps to inform and establish what that standard of care is. And so you want to comply with those things to the greatest extent possible. And one thing you'll notice in there that a lot of the recommendations in there are also applicable. They're really more applicable to the venue, the hotel or convention center, than they are to the meeting sponsor. It's a combination. And so another thing you want to do is make sure you have good open communication with the venue to get them to agree to as many things in there as possible. Sanitation, ventilation, food service is a big one, making sure that there's not going to be any, self-serve buffets and things like that, there's different ways that I've been to some conferences. There are safe and healthy ways to serve food and drinks in a way that helps to mitigate, the risk of COVID spread. And you want to make sure you get the hotel or the venue to commit to doing those things. So those are some of the things that you want to do to help ensure that you're not being negligent in how you hold the meeting. Now, beyond that, the big question that everyone's asking me about these days is vaccination mandates, and we all read about it every day and read about it in the news. Here's what I'll tell you, and there's slightly different rules for the workplace when you're talking about, like, are you going to mandate that your employees be vaccinated before they come into the office versus for meetings and conferences. And another distinction I want to make, so one is between meetings and the workplace. Another distinction is between mandating vaccination and requiring proof of vaccination. That's another distinction. And then I think a third distinction is there's a difference between a flat out vaccination mandate, say for your conferences, versus vaccination or proof of a negative COVID test, usually within 48 or 72 hours from the start of the meeting. The associations the ones that are putting in vaccination mandates are doing it both ways. Some are saying it's vaccine only and you have to require proof. Others are saying vaccine with proof or proof of a negative PCR COVID test within, usually most are saying 72 hours prior to the meeting. And some are even having on-site, kind of rapid test kits available for folks as well. So there's lots of different approaches. But in terms of the legal issues, the short answer is it is lawful for you to mandate vaccinations as a precondition of attending your conference, even without the exception for a negative COVID test. And it is lawful for you to require proof of vaccination if you want to. And frankly, if you are going to mandate vaccinations, I strongly recommend that you utilize, there's several companies out there that have services and apps where you have to pay for them to do it. One of them, the one that I've seen the most is the company Clear that does the airport screenings. They have a number of associations have used them for their conferences. It's not cheap. I think I heard yesterday on a webinar I was doing that they charge like $4 a head, per person, but for a larger conference that can add up. But then, that takes all the risk and all the concern away from you. It also mitigates the risk of fraud of someone, forging easy to do.
I need email address.
It reduces the risk of fraud from someone, fraudulently showing a vaccination card. And I actually utilized it myself for an ASAE event that I'm going to be attending, and it was super easy and quick to do. And then when you open the app on your phone, it pulls up a QR code, and then you just have something where you scan it, for your attendees when they're coming in. It's super easy to use. It's much more reliable in terms of reducing fraud, and it really takes a lot of the risk off of you guys. And so something to consider if you can afford that, if you are going to require proof of vaccination. Now, so you can mandate it, and even there are 5 states, 2 big ones, Florida, Texas, Iowa, Alabama, and I think it's North Dakota, 5 states that have laws or executive orders in place right now that say that it is illegal for businesses in those states to require proof of vaccination as a precondition to entering that business. Think restaurants, retail stores, hotels, things like that. But even in Texas and so except for Alabama, they don't ban requiring vaccinations as a precondition. They ban requiring proof of vaccination as a precondition of entering the business. But even in Texas and Florida, the hotel lawyers there so far, what we've seen anecdotally, is they've said, well, we can't require proof of vaccination for someone to walk into the hotel. You, who's just leasing space from us and to hold your event, you can require that proof of vaccination. And so bottom line, from a legal perspective, you can require it if you want. And as I said, in some associations, there's real pressure from the ground up to mandate vaccinations for all without even the option for a negative COVID test. Again, it's a very political decision. It's a very difficult decision. You guys have to, every association has to make that decision on their own. But there is one exception you have to make. Title III of the Americans with Disabilities Act says that in places of public accommodation, which include like hotels and convention centers and restaurants, if someone has a qualifying disability, for instance, a medical condition that makes it risky for them to get vaccinated, a COVID vaccine, then you have to make a reasonable accommodation for those individuals that still allows them to generally participate in the event. And so that's the only exception that you legally have to make. You've probably heard about another exception for a sincerely held religious belief that prevents you from getting a vaccine. But that exception, which derives from Title VII of the Federal Civil Rights Act, does not apply to conference attendees. Conference attendees don't have any protections under Title VII of the Civil Rights Act. Employees do. And so you do have to make that same exception in the employment setting. And I'm dealing with this quite a bit these days. And it's a really difficult issue because a sincerely held religious belief is very different from a sincerely held political belief. But there's a lot of blurring of the lines there. We're getting a lot of our clients that are, opening their workplaces back up and are getting requests for exceptions based on the religious exception. But that aside, in the conference setting, that doesn't apply. So it's just for the qualifying disability. So you have to make a reasonable accommodation. The two most common reasonable accommodations that we're seeing associations make, one is to just have the proof of the negative COVID test as the reasonable accommodation, even if you required it every day, that they come for it, if it's a multi-day event, that's fine. That can be a reasonable accommodation. And the other one is obviously if you have a virtual component to your meeting, and participating virtually, while it's not completely the same, that, and I can't tell you for sure because this stuff hasn't really been litigated yet, but that would seem to be a reasonable accommodation as well. And I've even seen some that are just making, the recordings and other things available to the individuals later. And so as long as you're doing one of those things, that should be a reasonable accommodation. That's the one exception that you do have to make if you're going to have a vaccine mandate for your conferences. So does that answer your question? I know it's a lot to digest, but that's kind of the current state of the law. And I got a question yesterday that said, of associations that you've seen that are holding in-person events or planning to soon, how many are requiring vaccine mandates? And I'd say the majority from what I've seen, definitely not all. Again, very political, depends on the nature of the industry or the profession represented by the association. We have a lot of healthcare related associations. Almost all of them, in fact, everyone I think that I've talked to is having either mandatory vaccines or vaccination or proof of a negative PCR COVID test. But in some others, it's not. In some other associations, and a lot of it's geographic based too, for an association that really is focused, from in one state or one region of the country and tends to be in kind of what we call the red states. Some of those, there's no way in hell that they're going to have a vaccine mandate. So it completely varies. It's a difficult decision, but that's kind of the state of the law as it stands right now.
Awesome. Does anybody have more questions tied to meetings? Or do we want to see if there's another topic?
Yeah, and we can talk about anything you want, any association legal topics.
Jeff, I was kind of wondering, okay, so you opened in January of 2020 before all this came down. What were you guys thinking you were going to focus on as a project?
Well, so it's interesting. And so while I'm spending all this time talking about COVID-related legal issues, and we have definitely spent, much of the last 18 months focused on COVID-related legal issues, the other association legal issues haven't gone away. So COVID ended up driving hundreds of new clients our way because they wanted help on all of these meeting cancellation issues. But what has happened is that many of them realized, oh, wait, these guys do all this other legal work for associations. And I'm not going to brag, but they're really good and they're really responsive and they're really practical and really cost efficient. So we're going to, ask them for help on this or that, everything from tax exemption and UBIT to antitrust issues to employment issues, copyright, trademark, regulation of lobbying and political activity, mergers, joint ventures, all sorts of other things, insurance coverage. And so all of the general stuff that we do every day, and every day is a mix of everything. We as I said, I have over 400 clients and we work with them on all of these different legal issues. None of that's gone away. And everyone's still dealing with those things and facing those issues. So that's what we thought we were going to focus. I certainly didn't think that we were going to focus so much on meeting contracts and events, but I've been doing this for 26 years. That's kind of the way it goes. When there's the big issues come up, we spend a lot of time focusing on that, but the other stuff doesn't go away either.
Are any of those issues, like what's the one that's coming right up behind COVID? Is there one that kind of stands out more than the others?
Not really. Not really. I mean, the issues that I've talked about today are things that we spend every day on, but other things, like there was one issue that we were spending a lot of time on leading right up to the pandemic, and that was kind of codes of conduct for in-person events, because we've seen, and as an attorney, I always get involved in this, doing internal investigations and trying to figure out member discipline and things like that. And there has just been, I don't know if there's more bad conduct at conferences in recent years, or just maybe more people are, sensitized to these issues, in part from the Me Too movement and just otherwise, or complaining or reporting about it more, which I suspect is probably the case. I don't think there's more bad conduct than there was in the past. It probably just, there's more sensitivity to it, which is great. But because of that, we've worked with many associations on kind of helping to write a code of conduct, which over the pandemic, we ended up expanding a lot of those from not just in-person events, but to virtual events as well, because we see a lot of bad conduct by members online, all sorts of really bad stuff. And I get involved in all of the disciplinary issues that come from that. Now, this is very different and distinct from like a code of ethics in a professional association that regulates members' conduct in their profession. Some associations have codes of ethics. If they do, they're either enforceable codes or aspirational codes. But that's very different from a code of conduct that regulates your members' conduct at your meetings and conferences and online, using the association's, online forums and listservs and other things like that. So anyway, I could talk all day about those issues. But, I think one thing also that this renewed focus on meeting contracts has also made a lot of associations more attuned to their contracts generally. And that's always been, it's kind of bread and butter stuff for, attorneys like myself and my colleagues, contract reviews. It's probably the thing we do more than anything else. Now, when you're reviewing a contract or drafting one, it brings in all sorts of other legal issues, which sometimes, need a real focus, or you got to figure out, is the income from this venture going to be taxable as unrelated business income, or is it going to be tax-free, or how do we mitigate our liability risk? How do we protect our intellectual property, like our copyrights? How do we make sure we secure the rights from others who are creating copyrightable content? We're going to let others use our trademarks, like our logo, what sort of license requirements do we have in place? And I think that there definitely is maybe a little more focus on, I didn't realize how important these contracts are, whether it's contracting for a new, technology or software, whether it's, what was one I was reviewing yesterday, an association that's licensing like a training program to state agency in Utah, things like that, realizing the importance of all of those provisions, from IP to liability to insurance, to everything else. And so that's a good thing. But I don't think I get asked that all the time. And it's funny, like the age old issues, from terminating an employee, to all of the issues I just mentioned and many more, avoiding antitrust risk, for anti-competitive discussions and behaviors and things like that. That stuff, the law really hasn't changed for the most part in any of those issues in all the years I've been doing this. And that stuff is still, some of the primary risks that associations face. In terms of ranking them, by far, employment-related liability risks are by far the biggest risks that associations have always faced. There's litigation filed against associations. You got employment suits up here, and everything else is a distant second. And so, if you're going to look at that in terms of risk management, you got to say you really need to focus on that and still deal with it. I was on an hour-long call yesterday figuring out a strategy for a client of mine that terminated an employee for performance issues, had tons of evidence of poor performance, yet the employee hired a lawyer, and the lawyer sent a demand letter saying, the real reason that you terminated my client was because of her age. Over 40, you're protected under federal law, and because of her religion, she's Jewish. And they said, no, the performance stuff was just a pretext. The real reason was you're discriminating against her because of her age and her religion. Zero evidence, and I don't believe that there was any discriminatory intent or motive in any way whatsoever. But anyone can allege anything, and now we're dealing with it, and now we're going to figure out how to. We'll end up settling it. We're not far apart, but it's just, it's unfortunate. But that's why I spend so much time drilling into my clients. When you have performance issues with your employees, you have to document it. You document, communicate it to the individual, keep a written record so that when it comes time, and it always comes time with some people that you have to let them go. If you can make this overwhelming case that it was performance-based and not because of one or more protected characteristics, you're a much higher likelihood that the employee will go away quietly. You might want to offer them some sort of severance pay in exchange for a release if it's a higher risk termination. But if you do that the right way, then you mitigate the risk of having to pay a lot out in severance or whatnot. And so that's one area of liability risk that's really important to focus on. I do a lot of work on employee terminations. I've actually done more work. I will say one area that has just exploded for us in the last 18 months has been CEO employment contracts. I don't know quite why. Maybe it's just my name is out there a lot. I'm getting a lot of referrals, but we work on them, multiple ones every week. Sometimes representing the association, sometimes representing the individual CEOs. But there is a lot of movement right now on the CEO employment front. And I've heard that from other people too. It's not just anecdotally. There's a lot of changes at the top in different associations. And the CEO employment contract is a really, really important document. I'm talking here too. I know a lot of CEOs or aspiring CEOs of associations, and having a good contract is really, really important. Another area of liability risk, not as high as on the employment front, but still creates a lot of liabilities, are certification and accreditation programs. So if any of you have or are planning to develop a certification or accreditation program, there's a lot of legal risk there, from antitrust risk to tort liability risk, defamation risk, and there's a lot of things that you can do to help mitigate that risk. But that's another big area. And just today, I got a correspondence from a lawyer representing a commercial real estate broker, alleging breach of contract for not paying a broker fee, even though there was no deal ever made. There was no arrangement to contract with a broker, and the association never made an arrangement with them and decided to re-up with their current landlord. And now the broker's coming back and threatening a lawsuit, claiming that they're owed whatever they're supposed to be owed from the broker fee. It's pain in the ass to deal with, but it's something that we'll deal with and see how it plays out. But those are just some top of mind risks of things that I've been dealing with the last few days.
Thanks. Jeff, do you mind if we just do a quick round robin to see if anybody's got a burning question that they brought for you?
Sure.
Okay. Susan, do you have anything?
No, I think you answered a lot, especially around like the earlier conversation about the contracts. Thank you.
Sure.
Thanks. Rebecca?
No, thank you. I think I was interested in on your COVID and the vaccines and all the things you had to say on that. So thanks for your comments on that.
Connie?
I do have a quick question. I am in the process of interviewing for 2 open positions. I'm curious to know about COVID vaccination, asking at what point is it okay or is it not okay to even ask about a status of vaccination?
Are you talking about in the employment front or the meeting and conference front?
No, this is for an employee for the association.
Yeah, so we didn't really talk much about this, but this is an issue that we are also working every day with different clients on helping them formulate their vaccination policy for their employees. And I should say, it's not just employees. If you're going to have a vaccination policy for employees, you also have to have it apply. There's a strong legal argument that you have to have it apply to any visitors, guests, contractors, others that are coming into your office. There's a claim that an employee could make saying, you're making me do this, but you're letting unvaccinated people come in, and therefore you're discriminating against me. And so if you're going to do it, you got to apply to all. So like I said earlier, it is lawful right now. There's no state laws that I'm aware of. That could well change, particularly in places like Florida and Texas, but there's no law that bans employers from mandating vaccines. And as you know, you've all seen what the Biden administration has proposed in terms of requiring large businesses over 100 employees to either mandate vaccines or have a proof of a negative COVID test every week. But in terms of your own association, you're free to do whatever you want. You do have to make 2 exceptions if you have a mandatory vaccine policy. You have to make reasonable accommodations for those with a qualifying medical condition under the ADA that prevents them from getting vaccinated, and for a sincerely held religious belief that prevents them from getting vaccinated. And that reasonable accommodation could be remote work, or it could be weekly proof of a negative COVID test. There might also be some other reasonable accommodations, but and you have to provide the reasonable accommodations so long as it doesn't pose an undue burden on the association. And second, so long as it still enables them to perform the essential functions of the job. So for instance, if the person's job requires them to be in person staffing your meetings and conferences and events, but they're asking for the reasonable accommodation to be remote work, that's not a reasonable accommodation because it doesn't allow them to perform the essential functions of the job. But anyway, as long as you make those 2 exceptions, then you can mandate vaccines. And you can require proof of that. But a couple of important things to keep in mind. One, there's a provision of the Americans with Disabilities Act that requires employers to keep confidential medical information, like sensitive medical information about their employees, strictly confidential. That's been around for a long time, since the law was enacted in 1990. And so what that means, and what the EEOC has said here, is that if you're going to require proof of vaccination, you can. It's not a HIPAA violation. You're not even covered by HIPAA in most cases. It's not a violation to ask for proof of vaccination. Don't ask questions like, why are you not vaccinated? Things that could elicit sensitive medical information. But you can ask for proof, but you should have just 1 or 2 key people, like director of HR or COO, or pick 1 or 2 people to be the ones to gather that information. And that information is, EEOC says, should not be stored in the employee's personnel files. Should be kept separately and under kind of strict lock and key. So what some of our clients are doing is having like the head of HR be the one to check people's vaccination cards and whatnot, and then keeping that information in a spreadsheet. Here's here they got the Pfizer vaccine, here's the date of the last vaccination, and just keeping that, in a strictly password protected document, that sort of thing. So if you're going to require it, that's the way to do it. You can obviously require your employees, if you wanted to use one of those apps like Clear or something, if you wanted to go that route as well.
Thank you. Jackie, welcome. Do you have any questions for Jeff? Okay, if you do.
I'm actually driving. Thank you very much. So I'm driving and listening at the same time. So thank you very much. Very informative.
Sure.
Okay.
I've enjoyed it.
Oh, good. You don't have any questions?
No questions at this time, but thank you.
Okay, great. Allison, welcome. You have any questions?
Oh, I just typed to you that I had to jump off, but no, and this has been a wonderful session. I really appreciate it.
Thank you for joining us. Tammy, any questions?
I do. Hi, Jeff. Nice to finally see you face to face. He's actually my lawyer. I have a question about the fully vaccinated. I know that now that they're pushing the booster, is there going to be, in your mindset or your thought process, of something coming down the pike to truly define what does fully vaccinated mean? And when we're asking for this information, will that be a part of the process of saying, are you vaccinated?
Yeah, it's a great question. And we've actually been already addressing that in some of the vaccination policies that we've worked on and written, in that, right now it's premature because, there's the FDA and the CDC haven't come out with that sort of guidance yet on boosters, but they likely will. They almost certainly will at some point. And what we're writing into the policies is that fully vaccinated means, that you're at least 2 weeks, beyond, the last shot, as, recommended by the CDC or something along those lines. So that when, say they come out with guidance that says, everyone should get a booster shot within 8 months of when, they got their last shot, something like that, then that will mean fully vaccinated. And that's likely going to continue and it may be forever. And so we're writing the policies to build that in. Right now, it just means from the first vaccination or the second dose if you had a 2-dose regimen. But yeah, it's a great point, and I think that's going to be the case because if the science suggests that your immunity and the antibodies are going to wane over time, and you want to still have the benefit of protecting all of your staff or all of your attendees, then absolutely that would be the way to do it.
Awesome. Thank you. Debbie.
No questions, Jeff. This is really helpful. Thank you.
Sure.
Marilyn.
I don't. I was just typing. I've got to jump off, but Jeff, this was excellent. I don't have any questions. What great information, and thank you so much for your time today.
Sure. If you guys want me to, come back and do this, in 3 months, 6 months, whatever, I have no doubt things will change quite a bit, and then we'll have other topics to talk about. But I'm happy to come back and do this every once in a while if you're interested.
Thanks. Heather.
Yeah, thank you so much for your time and really informative this morning. You've answered most of my questions, but you did bring up the topic you said you're seeing a lot of, and I'm sure it's a super easy answer, but maybe it's just the bullet point highlights on the CEO contracts. And I actually have, I feel fortunate that I did negotiate what I feel like is a pretty good contract with attorneys on both sides, right, recently. But what are you seeing, like what are the big issues if you were to give this group some suggestions that we should be keeping in mind, or what are you starting to see that maybe you haven't seen before in those kinds of contracts? Again, a super short, easy question at the end.
Yeah, I've given entire presentations on this for ASAE and others, for hour plus. But I think your question about what am I seeing that's new and different. I'm not sure that that's the right question, because there's not a ton that's new and different. There's definitely some trends and they've been going on for years. Trends like less perks and benefits and more just straight compensation, straight cash. things like that, because, well, for a variety of reasons, but some boards just don't seem to have the appetite for that. Then IRS Form 990 was changed a number of years ago to require disclosure of certain of those perks, like first class travel and other things like that. So a lot of associations don't want that disclosed on the 990. So we've seen some trends like that, but frankly, to me, it's not about anything that's new and different. It's the same issues that I've been dealing with for 25, 26 years I've been doing this. Things like, I'll give you a few things off the top of my head, making sure the CEO has the sole and exclusive authority to hire, fire, terminate, promote, all other staff within budgets set by the board. And making clear who does the performance review of the CEO. And when I'm representing the CEO, I want that to be the smallest group possible. And generally the people that work most closely with the CEO, like the executive committee of the officers, or even sometimes just the 3 top officers or something like that. The term and termination, they kind of go hand in glove. But how long is the term going to be? Is there going to be an automatic renewal feature? But most importantly, when can the association terminate the contract mid-term without cause? And if so, what sort of severance pay is built in? Severance pay and benefits, that when I'm representing the CEO, I'm always pushing to get COBRA in particular, because that's the really expensive one, covered during the severance period. Also, when I'm representing the exec, I'm trying to make sure that at the end of the term, if it does not get renewed, no automatic renewal or renewal period or no new contract, that the exec still gets some severance pay. I'm getting more pushback these days from boards. I'm often having to agree to like half of the other, the termination midterm during the term of the contract without cause, you get the full severance amount, say that's 12 months. If for a non-renewal, then you get 6 months. I've had more success doing that, but that's a trap a lot of execs forget about. They don't think about, and you can't always get it. Like some associations say, look, we're contracting for this 5-year term. If we decide not to renew, we're not going to pay you severance. But again, that's part of the negotiation. The definition of cause, really, really critical. Because if sometimes I see these clauses you can drive a truck through. It's so broad that if the association wants to terminate you, and they say for cause, it can pretty much be anything. And so really important to narrow that definition to the greatest extent possible. And there are ways to do it and that work and are fair and balanced for both sides. There is something new that I'm seeing, which is this issue of remote work, and like sometimes I'm representing, CEOs that get hired and they live in a different state, and they want to be able to generally remote work, but maybe come into the office 1 week a month or whatever the case is. So negotiating those structures, just because we're seeing that more and more, and even the decision as to whether like whatever the association's remote work policy is going to be, starting to write that into some contracts to make sure the CEO has control over those decisions, and you don't get kind of micromanaging from the board. Those are a few things. I'm working on one right now for a CEO of a very large association that we're exploring deferred comp options, because the CEO, it's going to be the CEO's last contract before retirement, and really wants to he's more interested in retirement savings and current compensation. But he also wants to do it in the most tax beneficial way possible. And so we're exploring various 457B and F plans to help try to maximize his tax beneficial deferred compensation. So those are a few things, Heather.
Wonderful. Thank you. Very, very helpful.
Sure.
Thanks. And we have one more question for you, Jeff. Barbara.
Hi, yeah, actually, I have a question also about CEO contracts, and that if you could just really quick, when does the lawyer get involved, and how small is too small? Like, for instance, I mean, I'm looking at maybe having a first opportunity to do a contract, right? But it's going to be pretty small. We're not talking millions of dollars in retirement plans and things like that. So
doesn't matter. I do. I work on these all the time, and some very small. If you're a CEO, you need to have an employment contract, because if you don't, you're an employee at will, meaning the association can terminate you at any time for any non-illegal reason. you have to have, in employment contracts, without question, there's much more benefit to the exec than there is to the association. There are benefits to both, for sure. But there are much more, there's much more of a benefit to the exec, even in a smaller association, A, because it limits the ability of the association to terminate you without cause. And B, it, to me, maybe the most important, other than guaranteeing you employment for a certain period of time, the other most important benefit is severance pay in the event that they terminate you without cause. And it doesn't mean in a small association, you're not going to get 12 months of severance for a termination without cause. You might not even get your health insurance premiums paid during the severance period, but even getting 3 months or 6 months or 4 months of severance pay can be really important. You know the nature of volunteer leaders, you all do. You know, they change all the time. Some are really fickle. Sometimes you get personality conflicts. Sometimes you just want to go in a different direction. And so you need that protection as kind of a glide path to your next position. It doesn't matter how small the compensation amount is. It's really important to have an employment contract. And in terms of the role of lawyers, so in most of these, once in a while, including recently, like I'll get on the phone with the lawyer for the other side, regardless of which side I'm representing, you know, to work out a few details. But that's the rarity. That's not the norm. Generally, I'm just advising my client, whether it's the association or the exec, in the background, you know, maybe putting together the contract or revising an existing contract or whatever the case is. But generally just advising my client in the background, and then they're having the direct discussion. Sometimes if there's a headhunter involved, the headhunter gets involved in those discussions. Sometimes they do, sometimes they don't. That can be a good or a bad thing, depending on what role they play. But generally the discussions will be primarily between the exec and like the chair of the board. And sometimes multiple people, but usually that's how the negotiations go. And there's some back and forth, and then, you know, I'll get on the phone with my client and we'll talk through. You know, I always want to understand what their priorities are. You know, everyone's a little different in terms of what they care about the most, and they always want to hear, if I'm representing the exec, all right, Jeff, what's missing here? You know, what's a best practice that's not here? You know, and that's where I often find things like there's severance pay for a midterm termination, but not for a failure to renew the contract and things like that. And we'll propose things like that and go back and forth. But ideally, you want the lawyers to stay in the background. And it doesn't have to be expensive. I'd say for most of these, when I'm representing the exec, our legal fees may be $2,500, something like that, maybe $3,000 at the most. And a lot of times we can get the association to agree to pay those fees, usually up to a cap. Sometimes they will, sometimes they won't, but it's a worthwhile investment, I can assure you.
Awesome. Well, with that, I want to say thanks again to Jeff for being with us, and thanks to all